Well, good afternoon to everyone. As Roger said, we hope you're getting lunch or have had lunch. Obviously, feel free to eat lunch whilst we're talking. We're talking today on two topics. The first, as you can see, is the credit hire update. I'm hoping on the screen you can, I've tried to share the screen and hopefully you can see the slides that we'll be presenting. This is being recorded, and I understand that a link to the recording will be sent to all attendees, or indeed those who said they were going to turn up but don't. So you don't need to take notes if you don't want to, and I think as well the actual presentation can be sent to you in addition. Just to introduce, I'm just looking at the participant names. Many of them are familiar to both Roger and I. For those of you who don't know who we are, we're both obviously at One Chancery Lane. Roger and I have more years than we probably care to admit fighting road traffic accidents, both for claimants and defendants, principally and quite often in a potential fraudulent context, not always, but also significant credit hire cases as well. As I say, that probably makes up the bulk of our practice between us. I think I'm conscious that we only have an hour to talk. There's quite a lot for us to get through. Just in terms of practicalities, there is, as those of you who are good at this will know, there is a chat function which I will have up and running. If people want to ask questions, and I know we've had a couple of questions in advance, we'll do our best to answer them as we go, but it might be that we type answers. But what we will try and do is at the end of the session have a short period of time where we deal with any questions that are of perhaps general interest and application, but please send them in onto the chat so that we know they're there. If either of us can deal with them as we go through, we'll type an answer as well. I hope that all makes sense, and I think probably without any further ado, I'll hand you on to Roger, who's going to talk first.
And thank you for attending today. As you can see, I want to talk about credit hire and essentially the case law since 2020, and particularly over the lockdown period, where despite lockdown, it seems that these sorts of cases have still ambled along, mainly by remote hearings and some in person, but certainly I've been doing 2 or 3 trials a week over the past year of this sort of nature, usually involving PI, but often also involving credit hire, sometimes credit hire alone. Now, so clearly issues such as need, rate, duration, mitigation, enforceability are heard daily in the courts. On the website of Chambers, you'll see, if you care to look at my profile, there's a couple of articles I've recently published, one on rehabilitation, fraud, layering and dishonesty and costs, which is also published in Foil, by Foil, and there's also one on fundamental dishonesty and trials in lockdown, which recently published too. So far as just maybe a chronological view of some of the principal cases in my view. The next slide, please, Simon. The first one is, as you can see, the case of Putter and RSA, clearly involving issues of impecuniosity, where the claimant's appeal against a substantial reduction in taxi credit hire claim was dismissed based upon a finding of pecuniosity due to credit card and overdraft facilities, which were in excess of the cost of repair. That's a principle also in Opoku and Tinnitus, which you'll know, where the Court of Appeal held that a judge is entitled to take into account a claimant's credit card facility and overdraft facility when deciding the issue of how a claimant can reasonably be expected to find funds. So the need or not for credit hire in the case of Putter could also vary throughout the period depending on his particular circumstances. So in that case also, it's notable that the claimant failed to provide a CPR compliant rebuttal to the defendant's BHR report, basic high rate report. So following that, in terms of tactics, I just suggest that both the claimant and the defendant, as always in these sorts of cases, should, in terms of disclosure, check again for periods and types and dates of full compliance with impecuniosity disclosure order. So often I find at trial that periods are missing, even just a week, from a defendant's perspective, I'll be arguing that, well, they've failed and so forth. Pecuniosity is the unless order, and it should be enforced. Sometimes there are unexplained transactions, but it's not just the obvious. In a recent case I did, which is referred to in the Fundamental Dishonesty in Lockdown article I've referred to, called IAS and Advantage Leeds. The DCJ in Leeds, Judge Gosnell, in January 21, it emerged during the trial, during the cross-examination really, that the claimant seemed to be taking rather regular sums out of his ATM, £200 here, £200 there, and under cross-examination, he ended up accepting that actually he had a gambling habit which he didn't want to tell his wife about. But yet he had such cash sums, and therefore he was found to be pecunious, despite him claiming the contrary. Next slide, please. Now, another issue, ongoing, of course, is the issue of fundamental dishonesty. And early in the year, in February, there was a case of Roberts against Kesson and Tesco. Section 57 of the Criminal Justice and Courts Act 2015 applied on appeal from a first instance finding of general damages and unproven hire claim. Here, the claimant had been dishonest in relation to the alleged write-off of his vehicle, which it seemed actually had an MOT passing at a relevant time. So the fundamental dishonesty finding was made even though the pre-accident value of the vehicle was not actually persisted at trial. Another case which involved fundamental dishonesty, this is a case in which I acted. It's reported in Westlaw and Lawtel, though the relevant part which I'm going to talk to you about costs didn't make it to the Lawtel website, and it's available if anyone wants to email me for it. So this had a long procedural history. It first of all got struck out on the basis of very late disclosure of an insurance policy at trial, on the day of trial, and on appeal it was sent back for trial on the basis that was a bit of a harsh decision, and also issues of illegality weren't quite right because it was for the claimant, the defendant to prove rather than the absence of the policy. But in any event, it went back to trial in Sheffield, and the interesting point here is that the claimant had his own claim for general damages in this vehicle that he said he was driving. His claim was dismissed as unproven in terms of breach of duty, but there was also fundamental dishonesty aspects as to his general damages claim. So fundamental dishonesty was found. But a particular issue arose as to whether or not his sister, who owned the car, but wasn't in it at the time of the index, but had herself a claim within the same proceedings for credit hire. The issue was whether or not in a so-called mixed claim, she had some form of protection of quox, as argued by the claimant. Now, after written submissions, District Judge Royal found not, and so she, even though she was not fundamentally dishonest in any way, was still liable jointly for those costs. Next slide, please. So, next case of interest, you'll see, I know it's a very dry topic, and I apologise about credit hire being a dry topic, but I'm trying to make it with my pictures as best I can, a bit more interesting. So you can see there some chimpanzees or monkeys having some fun looking through the hair for some lice or nits. And so in the ongoing skirmishes as to basic hire rates, typically the defendant would produce a report. Can you go back up, please? Typically a report, and the claimant may provide evidence in rebuttal or leave it to submissions of counsel at the very end. I often come across that with no report, me for the defendant, and claimant's counsel comes all at the end with lots of arguments about criticising the defendant's BHR rates, evidence and report. Procedurally, sometimes I think that's rather an unfair way, really, because had there been a witness statement or report from the claimant, the defendant would be able to at least look it up and react to it. But there it is. We just have to do it on the hoof, on the spot, in reply. But in any event, in the case of Bunting in the High Court, Birmingham, Justice Pepperell, a good case for defendants, really. It provides a common sense, pragmatic approach to the issue of assessment of BHR rates evidence. This concerns an RTA in 2015 involving a driver claimant who was driving a Lotus Driving a Lotus, he was pecunious, so that wasn't really an issue. There was a claim for hire of some, well, credit hire initially, of some £28,551 over what turned out to be an agreed period of 78 days. At first instance, matters turned upon the BHR rates evidence provided by the defendant, in a somewhat rare move, the claimant actually summons the defendant's author of the report for cross-examination at trial. The distilled issues were, had the defendant proved that there was a difference between the credit hire rate and the basic hire rate, and if so, what was it? So cross-examining included issues of vehicle availability, limited contractual duration, which the author opined could be readily extended upon request. The trial judge relied upon the BHR report and the lowest thrifty provided rate, awarding just under £4,000, which clearly was but a fraction of the amount of claimed hire. A rough and ready allowance of £10 was used to take account of the fact that there were no details of the deposit. The mileage was limited to 500 weekly and a 30-day maximum hire limit. The claimant appealed with criticism of the BHR report and the trial judge's acceptance of it. The grounds included that the BHR report was not in compliance with the order as to availability of vehicles at the time, the finding that the vehicle would have been available, and the 30-day limit of hire opined as extendable by the expert. The respondent to the appeal argued that the trial judge's approach was impeccable application of the Patini against First Leicester Bus 2011 principles, indeed, Mr. Justice Pepperell found in this case, although this appeal raises no issues of law in this heavily litigated field, but the recorder's decision was properly structured in accordance with the guidance given in Patini. So the real issue, the judge said in this appeal, is how the judge should have approached the imperfect evidence as to basic hire rate. This is not a new problem. It's long been the tradition of the Court of Appeal that county court judges should be encouraged to do their best with imperfect evidence. And the judge was absolutely right to rely on the report. It was the only evidence before the recorder. In any event, the judge's rough and ready additional allowance is precisely the sort of matter that is open at first instance judge to go by. Now, the court should be very slow to interfere, and what's the quote that no doubt all parties who are opposing criticisms of their evidence and BHR evidence, particularly defendants, the judge said, "This appeal is, I regret to say," and I quote, "a nitpicking challenge to the judge's findings of fact, best amplified in the fact that one of the grounds was just about the last day of hire and whether or not it ought to be £24 or not." It was also found, another point of interest in this case is that where there was the issue of deposits, which is often a point which is raised against the defendant's BHR rates report, is irrelevant where impecuniosity is not being alleged. So in terms of tactics, going forward, I suggest that perhaps the claimants may seek to increasingly obtain BHR report and evidence. And of course, they will no doubt be urged to focus on the best points, give me your best shot, rather than nitpicking at other points. Arguably also, claimants may seek to target the impecunious even more and try and prove that, or alternatively, potentially seek higher value vehicles for the pecunious cases. So despite the notion that Justice Pepperell thought that this wasn't a new area of law or new principles applied, it will nonetheless, I suggest, be a standard case in defence bundle authorities for trial. Next slide, please. Now, next case then, Duria against Bojaj. You can see my picture there of some rubbish. And so in this case, quite apart from the other issues in this matter, which related to postal service and whether or not what service was effective, and there was a relief from sanctions application in that regard, the issue still also is relevant to credit hire, and particularly regarding what's pleaded and the evidence of it in terms of impecuniosity. So following vague particulars in this instance, an unless order, which is quite common for credit hire directions was issued, including, presumably because of the vague pleadings, for a reply to the defence. And in particular, as to the facts in support of the assertion of impecuniosity, and requesting the usual specified financial documents for the 3-month period before the commencement of hire and so on. Now, Lord Justice Coulson held that the unless order had been breached, not only because of the late service of the reply, but also because the unless order had not been fully complied with. The requirement of the order was for the reply to set out all the facts relied upon in support of the assertion of impecuniosity, whereas the reply did not set out that income, expenditure, and how those figures meant he couldn't afford to hire the vehicle. The witness statement didn't expand much further, and the specifics of the financial situation therefore remained somewhat vague and unevidenced. These were considered indeed serious breaches regarding the relief from sanctions application, and the quote, which no doubt defendants will also rely upon, is paragraph 52, Lord Justice Coulson, who said that the submission seems to be based on the incorrect notion that claimant was entitled to advance, and I quote, a rubbishy case in stages, hence the picture. From pleading to a witness statement to trial, presumably in the hope that by the time the trial came on, there was a commercial imperative on the part of the respondents to settle the case. So don't, in terms of tactics, apply a rubbishy case in stages, make the case clear, and certainly pay greater attention to what's in the witness statements as to proving the case. So whilst the Practice Direction 16 in April 2020 requires more specific pleadings, this is in the case is still a useful reminder. The directions, of course, do vary slightly from court to court in terms of the impecuniosity directions. I would urge, from a defendant perspective, to be very particular. If, for example, trying to get in an order for disclosure not only of the claimant's financial documents, but also anything where there's a jointly held document, jointly held account, in particular overdraft facilities, credit cards, documents, and so on. From a claimant's perspective, of course, the more bland the direction, the better. And from a claimant's perspective, sometimes, as the case I had earlier this week, that there was at the trial, I noted that the original directions order for impecuniosity included a sort of saving clause of the unless order subject to permission of the trial judge. That isn't always there, and that might encourage some very willing judges to be a bit more exercising in that regard. Next slide, please. Now here, I'm referring to the case of Puku and Abedin, and you can see here I've got is that there are 3 magician's cups, if you like, and we can see, looking at that, we know there is a ball, and likely there is not one in 2 of them, and no matter how much they shake them around and move the cups on the table, nonetheless those who are watching do know that there's a ball there. So that perhaps is demonstration of the fact that in terms of alleged abuse of process, the question is where credit hire claims are not pleaded at every stage in all of the documents, for example the CNF or stage 2 portal. So in this regard, whilst the defendants saw victory in the case of Hillier against Southern Rock earlier in 2020, where proceedings for credit hire were struck out on the basis that the whole claim had been settled in the RTA portal of personal injury, let's say, that decision was upheld on appeal and permission to the Court of Appeal was refused. So, of course, defendants there are somewhat buoyed at the position. However, matters did not rest there. There was a victory for the claimants in the latter part of 2020 in the case of Puku against Abedin, 8th of October 2020, I think handed down in November, where on appeal in the Central London County Court, Her Honour Judge Backhouse found that there was no abuse of process found here. Although the claim notification form and the portal made no mention of a credit hire claim, it was found that the defendant must have known that this was a mistake and knew all along with the credit hire claim. There was correspondence and dealings for example, an intervention letter, an instruction to deal with defendant's appointed credit hire agent. But it was found on appeal that the defendant could not have a windfall in these circumstances when taking into account all the circumstances in accordance with the test in Johnson and Gore Wood. This was distinguished from the Hillier case as there was instantly no evidence of a full compromise, whereas in Hillier settlement was banked on a full and final basis. Now, although much of the case law, such as in pecuniosity rates and so on, has in 2020 been good for the defendant, this case of POCU is comfort for claimants. It doesn't go only one way. So indeed, there is a note I've seen on the generally available on the internet from one Peter Jarman, who is the managing director of the claimant solicitors in that case, and seems to have this as a cause, setting out that since that POCU case, on the 15th of January 2021 in Nottingham, His Honour Judge Godsmark awarded some £20,000 of wasted costs in relation to two appeals, one called Griffiths against Rust, another Anderson against Samuel Higgins, against findings of abusive process in small tract claims on the basis of compromise. The appeals were eventually consented, it seems, by his note, by the defendant's solicitors on the basis of evidence and weight given to the prior correspondence. Mr. German, in his note, suggests some tactics for claimants in this regard. He says that he's been seeing lots of cases where there's of this nature of abusive process arguments, and he says in his note, and I quote, "Make sure where you see these defences, you seek disclosure of," and he emphasises all correspondences, "and watch out for the tactic from a certain insurer of making attractive pre-medical offers PSLA, then adding that the acceptance is in full final settlement of the claim, which would prejudice vehicle-related losses and not included in the MOJ portal." So clearly there's some sort of insinuation there that a particular insurer is up to no good by adding in full and final settlement at the very last moment. But arguably, in terms of tactics, clearly the claimants should check before they bank and make sure what's in the the wording and whether or not it's agreed. It would be prudent to indicate that any settlement stage 2 is without prejudice to vehicle losses claim, for example. So until there is a higher precedent, it would be prudent for defendants to limit perhaps the abuse arguments to very clear compromise cases such as Hillier, but still, even then, strikeout may be disproportionate. It's a fact-by-fact case basis. From my point of view, as a trial advocate, it is the case that at trial, certainly for the defence, I really prefer to be dealing with both the personal injury and the hire in one case, because that way I can try and get the credit hire, which is usually a very large sum, dismissed on terms of fundamental dishonesty of, for example, the medical issues. There are many examples of that in my portfolio and no doubt in the courts across the land. So in terms of trends going forward, clearly cases such as POCU are examples where it's prudent for a claimant to perhaps these days, and especially in the onset of the new Whiplash Reforms, which Simon will shortly talk to you about, to try and part the issues and get settlement or otherwise of the medical issues, and then take the credit hire separately, because these, potentially there may be no advantage to a claimant to join along, a small claims track personal injury claim, because the issue of fast track costs is no longer potentially an issue that would bump things up for them. Rather, they may be pulled down by the whiplash claim if it's found fundamentally dishonest. Recently, in a CCMC only a couple of weeks in Bradford, I managed to persuade the judge to include in the standard directions, the directions, that the claimant was to notify in writing within 7 days whether or not he is actually pursuing a personal injury claim, because that wasn't evident on the papers at the CCMC, which were only related to credit hire. So there is also just an issue, which perhaps is an issue might be there going forward, in terms of duplication of costs, if they're separate to representation, for example, or separate hearings. And in the past, I certainly have had I think at least one claim struck out on the day of trial by deploying the case of Lewis against Daily Telegraph on the basis that the claimants turned up with two representatives, two solicitors, on the day of trial, when really they ought to have got permission for that, because clearly there shouldn't be duplication. So just the next slide, please. So there it is, from my point of view. There's a link to the articles that I've referred you to, and if you get time, have a look at them. And that's my element of this scenario. Thank you for attending. Over to you, Simon.
Thank you, Roger. Roger, just to let you know, I don't know if you could see it on my screen, I've been answering questions on the chat as we go. You might want to, if you can access it, might be worth just checking that you agree with my answers or wildly disagree. I'll leave you to form a view either way.
Thank you.
I'm now going to talk on the Whiplash Reforms, and I want to start with quite a large caveat. The Whiplash Reforms are, as you can see on the front page, they're due to come in on the 31st of May. Everything seems to be pointing to that they will come in force on the 31st of May. They're not retrospective. They are going to deal with accidents occurring on and after the 31st of May. So obviously it will take some time to bed in. The caveat I want to add is this is a wholesale change to the way in which such cases are dealt with. There are now various different documents and forms that exist, and you can do no better, I'm afraid, than actually going to the source material and reading what it is, because there is quite a lot of technical matters that arise from a consideration of the new proposals. What I propose to do is just give you a broad outline of how it all fits together, where you can look for answers to questions, and give you a few indications of areas where I would have thought there may be issues and problems moving forward. But ultimately, as I say, I think you are going to need to look, I'm afraid, at the reforms themselves and the new documents on any specific case you might be dealing with. With that as a background, let us deal with the current system. I'm conscious that there's a whole range of experience of people listening into this talk. There'll be some at the one end who may know little about whiplash cases. There'll be others at the other end who are partners in firms very used to dealing with the system and the intricacies of it. So I'm going to skate quite quickly over the existing system and the reasons why this is all coming in, but it's important just to put the background in. As you all know, at the moment, there are pre-action protocols dealing with low-value personal injury cases. There was a change in the rules that many people may well have thought are only still bedding in, which was to bring in effectively fixed costs in such cases. It brought in qualified one-way cost shifting so that the deal was effectively done, that a claimant who succeeded on a whiplash case, their costs were limited, but they were no longer allowed to claim an uplift from the defendant. They were no longer allowed to claim an after-the-event insurance policy premium from the defendant. And a defendant who was successful agreed, subject to, as you can see on the screen there, as you all know, a couple of obvious exceptions, 4415 being effectively strikeout, 4416 being fundamental dishonesty. Unless those raise their head, the defendant, even when successful, was not entitled to enforce their costs, of course, over and above any award that was actually made to a claimant. Broadhurst and Tanwick probably should have ridden the coach and horses through this whole system, because it does allow a claimant to recover old-fashioned indemnity costs if a Part 36 offer is beaten. In reality, hasn't largely had that effect, certainly in my experience, because claimant solicitors have not been competent enough to make good offers early enough, and when they have and have been sensible enough, more often than not, they seem to forget that they're then entitled to indemnity costs at the end of the case. So there is that mechanism. That is the current system. That remains the system for all accidents, road traffic accidents, before the 31st of May. Why is all of this happening? Why are we suddenly entering into a brave new world? I put this quote up before, and I'm going to put it up again. You'll see at the bottom that Chris Grayling said, that those of a longer age will remember who Chris Grayling is, that the reason why they had to do something about this whole system was to reduce insurance premiums to help with the cost of living. Fraudulent, exaggerated and unnecessary insurance claims continue to place a significant financial burden on each and every motorist. I confess I'm still not quite sure what an unnecessary insurance claim is, if it's not fraudulent or exaggerated, but there it is. That is the target of these reforms, is to bring down your insurance premiums for everyone because there are said to be too many fraudulent, exaggerated and unnecessary insurance claims. So that, and I will revert to that at the end, but bear that in mind, that is what we're seeking to remedy by changing the current system. Looking at the current system, there are a number of new documents and new sources of material that you're all going to, I'm afraid, have to get familiar with. And what I'm going to do is this talk is effectively talk through each of these bits so that you get a handle on where they fit into in terms of this new brave world that we're entering into. The starting point has to be the Civil Liability Act of 2018. We'll look at the terms of that in a moment, but the Act defines in very simple terms whiplash injuries, and it states where whiplash injuries arise, one can have regulations fixing how much the damages should be for whiplash injuries. It also states that under the, pursuant to the Act, that the regulations can also deal with quote unquote minor psychological injuries sustained at the same time. There are still draft regulations, and they're draft, notwithstanding this is coming in a few weeks' time, the Whiplash Injury Regulations of 2021, which does exactly what it says on the tin. It provides a tariff. Again, it will be clear, but it's worth emphasising, cases that fall into this regime are no longer compensated by reference to the JC guidelines, as we're all familiar. They are compensated if they fall into the Civil Liability Act and the regulations by reference to a set tariff. So that's the sort of statutory framework in the background, which we'll look at. To put all of that into force, there are two key new documents that you will have to become familiar with. They are very unusual documents in the way they're drafted, and I suspect that's because they are drafted with a view to an awful lot of claimants now acting in person. And so I think the idea behind it is that they are user-friendly. I don't think they've succeeded in that idea. I think, in fact, by trying to explain every possible conceivable eventuality so that you have a practice direction running to over 70 pages, a new pre-action protocol running to over 70 pages, a new document called How to Claim, which claimants are supposed to read as well, and an online portal, I suspect many claimants with a personal injury claim will throw their hands up. So I would anticipate that people who wish to still bring a claim are going to require assistance with all of this. The topic, again, I will come back to in a moment. But for present purposes, you need to be aware that there's a new practice direction to Part 27. It's Practice Direction 27B. I've put in there just a couple, just to give you a flavour for how this all works, of the new forms and names of forms we're all going to have to get used to. There's an RTA-SCL, an RTA-SCQ, an RTA-SCD, there's an RTA-SCO, and there's various other documents, in fact. Again, I mentioned them, well, we'll look at them in a little bit more detail as to what they are in a moment, but just to flag up to everyone that this is an entirely new framework, and so will require you to look at it more carefully. Hand in hand with the practice direction, there's a new pre-action protocol, possibly the snappiest titled yet, the pre-action protocol for personal injury claims below the small claims limit in road traffic accidents. Again, like Ron Seal, although other paints are available, it does exactly what it says on the tin. It is a pre-action protocol for claims arising from road traffic accidents that fall below the small claims limit. Hand in glove with those documents, there's going to be an amendment to Part 26. There's various other amendments, but there's an amendment to Part 26, and the amendment to Part 26 is that in turn, which is of the CPR, which is of course case management allocation, that the small claims track is going to increase where one is dealing with personal injury. At present, of course, where there is personal injury that is likely to be valued over £1,000, then that would take you out of the small claims track, or it would not be the normal track. In cases, and it's clearly defined, of road traffic accidents occurring after the 31st of May, that limit, subject, as you'll see, to some exceptions, increases to £5,000, and in reaching that valuation for any whiplash element of the case, you arrive at the valuation by reference to the tariff under the regulations. I just pause there just to, again, we'll come back to this, but to emphasize the point, you have to have in your mind two separate issues. The first issue is whether you're dealing with a whiplash injury as defined. That's defined by the Act and to which the regulations apply, and that includes minor psychological injuries. But in fact, of course, you can suffer other injuries in a road traffic accident, and the small claims track increase applies to all such claims. So if you had, for example, a whiplash injury as defined together with a twisted ankle, that, all other things being equal, if it was a minor twisted ankle, the minor twisted ankle would be valued by reference to the JC guidelines, the whiplash injury would be assessed by reference to the tariff, the cumulative total, assuming it's a road traffic accident, assuming it's after the 31st of May. If it's over £5,000, this doesn't apply. If it's under £5,000, it does apply. The top of the bracket for the small claims is still £10,000. But again, that is qualified because there is a, well, I'll come back to that in terms of how that interplays with credit hire cases at the moment. At the moment, as I say, £5,000 for the personal injury where it's road traffic, the upper limit is still £10,000. The other thing that everyone will need to become aware of is the online portal, the official injury claim run by the MIB. It is a requirement of any case that falls within the practice direction, which, as you can see there, is for personal injury claims below the small claims track limit following road traffic accidents. It is a requirement of that the claim is pursued pre-action under the portal. And it's an online portal. There is, God help one and all, an outfit who are supposed to be out there to assist people who are not IT literate, who have difficulty with claims. Speaking with my Deputy District Judge hat on for one moment and having to grapple with litigants in person who simply can't marshal the basic requirements of Teams or indeed even answering a telephone call, the thought of how litigants in person are going to deal with this online site remains, I think, a surprising mystery. It's important to note who this all applies to. The practice direction does not apply to pedestrians, motorcyclists, cyclists or children, a point I'll come back to in a moment. So let's take it in stages. They're the general documents that we all need to be vaguely aware of. Starting point, as I said, is the Civil Liability Act, which, as you'd expect, defines whiplash. One of the questions we had in advance is what issues might arise moving forward. And certainly, in my view, one of the issues that arises is how whiplash has been defined. So I've put it up there, the test. Section 1.1, whiplash means an injury of soft tissue in the neck, back or shoulder that is a description falling with subsection 2. So just, let's put that in. That's a sprain, strain, tear, rupture or lesser damage of muscle, tendon or ligament in the neck, back or shoulder, or an injury of soft tissue associated with the muscle, tendon or ligament in the neck, back or shoulder. So it's one that falls within that, but not including. So in other words, a whiplash injury is not one that includes an injury accepted by subsection 3. And subsection 3, an injury is accepted if it is an injury or soft tissue which is part of or connected to another injury, and the other injury is not an injury of soft tissue in the neck, back or shoulder, or of a description falling within subsection 2. There is no assistance with when another injury might be said to be connected to the neck, back or shoulder injury, which certainly on one reading of this would take it outside of it being a whiplash injury. Clearly, the idea behind all of this was if, for example, you suffered a traumatic brain injury because your head was thrown around with such force, and as part and parcel of that, you suffered a whiplash injury, I think the intention was that the whiplash element or the pain in the neck element shouldn't take this into the whiplash injury definition. Certainly that's my reading of it, but quite when an injury is associated as distinct from connected to, I think remains to be argued. And it's going to be quite fact sensitive. And as I say, it seems to me, certainly on one reading, that if you can say your other injury is connected to your neck, back and shoulder injury, then it seems to me you might arguably say, well, none of this applies to me, and therefore my neck injury, back injury, shoulder symptoms aren't caught by the tariff. I leave that there for thought rather than for an answer. Some of the edited highlights from the Act: it only applies to cases where it is unlikely to exceed, the injury is unlikely to exceed 2 years. So if your injury is likely to exceed more than 2 years, you're not in this, you're not falling within this definition or tariff. The 2 years is, as you're seeing there, if it would be expected to last less than 2 years, but for the claimant's failure to reasonably mitigate. All lawyers' antennae should probably twitch at that point, because that's just going to raise arguments just what's meant by failing to reasonably mitigate. When can a claimant be said to fail to mitigate? Obvious examples are going to be things like not undergoing physiotherapy when recommended, but again, it's clearly going to be a potential area to challenge whether the tariff applies at all if you have a longer lasting injury. As I've put there, another area where it's likely to be challenged is that the Act allows for minor psychological injuries sustained at the same time. But oddly, there's no definition of what defines it as being minor. Is it minor by reference to how long it lasts? Possibly, but possibly not, because the tariff is done by duration. But what is minor? Is a 2-year travel anxiety minor as compared to a 3-week post-traumatic stress disorder? Discuss. It's not defined. And that, I think, will probably, again, be an area where there'll need to be some relatively clear judicial determination as to what constitutes a minor psychological injury. Motorcyclists are excluded by the Act. Lots of other people are excluded elsewhere, which I'll come on to, but the Act excludes motorcyclists. As the Act makes clear, the Act does not prevent damages being awarded for another injury. So, as I say, if you twist your ankle, bang your elbow, suffer tinnitus, to raise some current claimant favourites, those would appear to be compensated outside of the tariff, but of course still caught by the increase to the small claims track and the practice direction and the like. There is an allowance for an exceptional circumstances uplift. It's now fixed at an uplift of a maximum of 20%. No guidance as to the circumstances in which it would apply, save that it's said to be either particularly severe injury or the effect is said to be particularly severe, but it's unclear how that's going to be interpreted. It's also unclear why it's not just a fixed 20%, and who would get, what exceptional circumstances would justify a 10% increase rather than a 15 or 17%. Again, up for discussion, but given the tariff, which we're going to come on to in a moment, it may not make a huge amount of difference, because 20% of not a lot remains not a lot in simple terms. Again, important for the whiplash element of any case, so an injury that falls within this definition, a regulated person, which effectively for these purposes is the insurers and the like, may not settle a claim before appropriate evidence has been obtained. That is going to be defined by the regulations. Just as a pure semantic point, the failure, the attempt to settle without having a medical report, strictly under the Act, does not render the agreement void. It's a regulatory matter. That probably is a theoretical rather than a practical difference, but it's perhaps important to know. Likewise, under the pre-action protocol, you're not supposed to settle, and it refers back to the Act, without the whiplash injury without a medical report. But it doesn't, or I think it'll be up for arguments whether that would render a potential settlement voidable, or whether in fact that's just a regulatory matter. I anticipate the courts would look to hold that any agreement reached was in fact binding, but interestingly the Act doesn't say that, as it could have done. The regulations I've already dealt with. They're still draft. The figures might change. Who knows if they'll be in time, but that's where we're at the moment. They deal with a tariff to be awarded with whiplash injury as defined by the Act, together with a minor psychological injury. The big head change that anyone dealing with this needs to get round is that the JC guidelines go out of the window. There is no distinction for the actual pain, suffering, loss of immunity sustained. It's also, I think, quite interesting. You'll see there in the second bullet point, I say it's unclear how a 12-month psychological and 3-month whiplash would be compensated. And when I show you the guidelines itself, you'll see what I mean. And I've mentioned there's an exceptional circumstances uplift to 20%. So here is the tariff. So they are the figures as proposed at the moment. The things to get your head around, and any lawyer who's used to dealing with personal injury may well slightly balk at this, It's interesting to note, for example, that a person who suffers a 3-month whiplash injury gets exactly the same amount as a person who suffers 6-month whiplash injury, or let's say 5 months and 29 days injury, even though they've suffered symptoms for twice as long. They get £495. Doesn't seem fair, but there we are. That's the system. If they've got a minor undefined psychological injury as well, they get £520. But as I say, what happens if they've got 24 months of psychological injury at a very minor, I'm a bit scared in getting in the car level, but up to 3 months of physical injury? What do they get? Answers on a postcard. It seems to me there is a tension there. It seems to be assumed that any minor psychological injury will resolve within the period of time that the physical injury resolves. That's not my experience. Quite often, that's not my experience. It might also, as it's not defined minor psychological, it is clearly intended that the medco expert will comment on psychological injuries. So you're not going to have a psychiatrist or psychologist commenting on it to save him more serious cases. So you're going to have the usual doctors, Saeeds and the like, commenting on this is a 3-month injury or a 6-month injury, and then the court's going to grapple with how that fits within the tariff. The 20% is fixed by the regulations. You can see there at 3.3. Remember, of course, if you're wondering about hands at 24 months, you fall outside of the Act at that point. I put the last line there because I hope most people on this call find this mildly amusing. The appropriate evidence of injury is defined by the regulations as being a report from Medco. I say nothing other than that's quite an interesting juxtaposition of definitions. Moving on, the link changes. This all comes in from the 31st of May. As I say, the regulations aren't in yet. I don't think there is, in fact, a date yet, but I'm sure they'll try and tie it into this. I've already mentioned one, that the CPR Part 26 is being amended so that the lower figure of £1,000 increases to £5,000, but only in road traffic accident cases for accidents occurring after the 31st of May. There's a long list of exceptions, which this isn't all of them, but it's some of the edited highlights. Children are out, protected parties are out, undischarged bankrupts, bizarrely, are out, pedestrians are out, riding a horse, you're out, using a wheelchair, you're out, mobility scooter, you're out, pedal cycle or motorcycle, you're out, and for the travel conscious amongst us, defendants' vehicles registered outside of the UK, you're out. You're not caught by this increase. Please note that is not the same list of people who are excluded from the Act. So a child is not excluded from the Act. So a child is caught by the tariff, but not caught by the increase to £5,000. So you may still, that's important because one of the reasons why children were supposed to be excluded was because of the difficulties they may find in dealing with the portal and the like. And indeed, they are excluded from the portal and the practice direction. But they're still going to get, if I go back to the tariff slide, they're still going to get, if they've got their 3-month injury, £240. But there it is. So you need to be very careful to look at your particular claimant to see whether they fall in the Act, see whether they fall within the amendments to Part 26. There is a new pre-action protocol that goes with all of this. It is, as I say, in many ways as a lawyer and or having legal experience, the document is relatively easy to follow, if not a bit laborious. There are a lot of new terms, there are a lot of new ideas or concepts that need to be grappled with, but ultimately it's very straightforward to read through the 70-odd pages of it. It says on its face that it's a new scheme for personal injury claims that fall within the new small claims track limit, being, as we now know, £5,000 up to £10,000. As with all other pre-action protocols, the sanction for non-compliance is you issue the case and then the court can come down on you like a ton of bricks. The concept, a little bit like those who are dealing with lower value personal injury cases at the moment, a bit like the stage 1, stage 2, stage 3. The idea of this is that in theory, a case could be dealt with entirely within the protocol and the court could have absolutely no involvement at all. That would be the best of all worlds. No doubt from the court, or certainly from the Lord Chancellor's point of view. But there are various ways in which you move, and this is something to get one's head around. You move from the pre-action protocol, or you can move from the pre-action protocol into the court And then rather oddly, you can then come back out of the court into the pre-action protocol. And then in theory, if it goes wrong again, from the pre-action protocol back into the court again. And you can certainly do that twice. In fact, you could do it 3 or 4 times, depending on how badly wrong it was all going. And I'll look at how that happens in a moment. But as I say, as a concept, one needs to get used to the two, the protocol and the new practice direction, very much need to be read together, because you may well end up passing from one to the other and back again on more than one occasion, depending on your case. All claims have to go through the portal. There it is. There's the website if anyone wants to click and have a look. There is a portal support centre. I think it's based in Milton Keynes, of all exciting places, for the computer illiterate, which is important. I suspect they're going to be very, very busy, certainly to begin with. For some people on this call, this is perhaps important to know. If you allege fraud or fundamental dishonesty, the protocol no longer applies to you. So that is important to know. Again, important just to re-emphasize that this is irrespective of the Whiplash reforms, by which I mean the definition of whiplash. So the personal injury going up to £5,000 catches both the whiplash injury and the associated injury, but does not, but the small claims upper limit of £10,000 still applies. The reason I pause there, or stutter there more accurately, is another definition that we need to get used to is protocol damages. There's a thing called protocol damages and non-protocol damages. And protocol damages can be vehicle damages or injury damages, and non-protocol damages can be vehicle damages and injury damages. The big way to understand it, they're all defined terms, is protocol damages are things that the claimant has paid for or has suffered as a loss. So, for example, if he has paid his car excess, that is a protocol vehicle damage. Non-protocol damages are damages that he or she is not going to be paying themselves, but is going to be passing on to a third party. So, for example, credit hire or hire that he's not paid for, that is a non-protocol damage. Pre-accident value is expressly dealt with unless the claimant's paying it himself and is not going to get it back from his own insurer. That is a non-protocol damage. The reason I put all of that is in assessing whether you fall in the pre-action protocol, you're looking at only protocol damages. So if you have a stonking huge credit hire claim, you ignore that. If the rest of your claim is still under £10,000, you go into the pre-action protocol. That's quite concerning, I suspect, for some people, because liability can be dealt with on the pre-action protocol. So you could, in theory, have a £200,000 hire claim, but the rest of the claim is a bit of whiplash and a little bit of other things, and liability is an issue. You would deal with liability under the pre-action protocol, and with the rough and ready nature of that and small claims track hearing, notwithstanding that arguably, although it's not strictly binding, but arguably that determination is going to dictate what happens to your subsequent credit hire claim. And that might send a frisson of fear up some defendant and jurors. Another important point is you can only make one claim at a time. And so if, for example, you're a claimant solicitor instructed by all the passengers in the car, every single one of them has to make a separate claim. The system, pause for laughter, is supposed to pick up the fact that there are other claims arising out of the same accident and tell you all. The reason it's supposed to do that is so that if you do have to issue your claim, you're supposed to tell the court about all these other accident claims, so the court can then make directions as appropriate, either consolidating them or staying various things. I put there, I'm not quite sure what the GDPR implications of an online computer system telling you about the details of other claims is. Someone far more GDPR savvy can tell me about it, but that's the idea behind it, so that each claimant will be then told, and of course you must tell the system if you know of others, so that the court ultimately can make a decision. I'm conscious of time, I'm going to go through these quite quickly. The pre-action protocol I've put there doesn't apply to children, but children at the date the claim was made of interest. Again, there's protected parties, vulnerable users, a very similar list to those that I mentioned about the practice direction as well. There's a supporting guide to making a claim, which you find on the website. What you do, let's talk through how it works as a pre-action protocol. The concept is you deal with liability first, The SCNF is a new form called the Small Claims Notification Form. That's what the claimant finishes. It's sent to the defendant by the claimant themselves if they're represented, or by the compensator, that's the insurer in simple terms, if the claimant is unrepresented. The defendant, therefore, is actually the other driver. Compensator, our insurer, can then admit liability in full, in part, deny, or admit the claim but deny it caused injury. They're your options. If you deny in full or part, you have a bouncing system whereby you make offers to each other. The offer system is actually quite complicated. I'm not going to talk you through it. It's worth looking at. But effectively, you can make up to 3 offers to each other. In other words, haggling over liability. And then if you fail to agree a liability, you then bring your claim, hence why the reference to CPR 27 PB there. That plays out as dealing with liability just in further under the protocol. If you haven't responded, if a defendant doesn't respond within the time frame, which is 30 days, you're taken to have admitted liability in full, and in fact you can't then argue the claimant wasn't injured. So it's pretty draconian. If liability is admitted in full, or if part admitted and the claimant accepts your offer, you then proceed to quantum. Quantum, as I say, for the whiplash element, you need a Medco report. It's a requirement of it. It generates instructions for a litigant in person on the online system. If they're unrepresented, the defendant has, or the compensator has to pay for the report. You get a report. The doctor is asked to comment on exceptional circumstances, if that 20%, if it's being claimed for. The claimant is asked to say whether he's claiming it. The doctor is also asked to comment if the defendant has said that injury wasn't caused. You will have Dr. Saeed telling us that he thinks injury was caused. That is not binding, and if the compensator continues to say after the Medco that no injury was caused, then it falls out of the portal. If you can't agree quantum, and again there's an offer bouncing around offer system, you can then go back to court. So you could have gone to court for liability, and if you do, you go into the practice direction. At the end of that, you come back for quantum. If you can't agree quantum, you go back under CPR 27B for quantum. Let me move on. That leads you to this horrific table. This tells you how the practice direction is set out. There are sections in the practice direction dealing with all the various options. So liability is disputed in full by the defendants. That's section 2 of the practice direction. If that's where you end up, the claimant fills out the RTA SCL form, and that takes you off into the practice direction, CPR Part 27B, and that's the form that starts those proceedings. But there's different forms depending on why you're going to court. So if the dispute now is just quantum, liability has been dealt with, but there's no vehicle costs and there's no claim for uplift, then you use an RTA SCQ. If quantum is in dispute and liability is in dispute in part, so there's an argument over contributing negligence, you can have non-protocol vehicle costs and an uplift claim. If that's where you end up, you need this court form, and so on and so forth. You'll see that a claimant might make a request for an interim payment, which if that isn't, that can be dealt with by the court. If it isn't granted, there's a form for that. If it's not paid, there's a form for that. If you're starting the claim because of limitation, it's very similar to the existing system. You can issue and then stay it. There's a form for that. If there's a dispute over the fees that the claimant is claiming for the cost of various things, there's a form for that. And if the defendant doesn't pay up, there's a form for that, although you'll note the last few forms are the same. So as I say, the form that the claimant starts with is determined by why it's going to court. So you're under the protocol, you've got your liability dispute, and let's say with liability, it's not been admitted and it's denied and you're off to court. The claimant, having attempted to settle liability, fills out the relevant form, the correct RTASC form. That, oddly, has to be sent to the court and the money claims as a hard copy. So they have to print it out and sort that out. There's no online system for a claimant to start this bit of the claim. Once they send that form, that stands effectively as the particulars of claim. Defendant isn't required to file a defence. They do an acknowledgement of service in a prescribed form. You have to do it in 14 days. If you don't, you can't file any evidence and you need permission to even get involved. You have to notify the defendant of the non-protocol vehicle costs. So a claimant is required to tell the defendant about the credit hire, the vehicle-related damages, all of those claims that they are not personally going to bear but will be passing on to third parties. Those are called non-protocol vehicle costs. Credit hire, accident damage are going to be the two most common. They have to be notified, and they have to be notified to generate something called the court pack. The court pack is a bundle of documents that are you enter them as part of the portal, such as photographs, such as statements, and once they're all in, that generates a court pack, which is then the hard copy that is used for the claim for a judge to decide the claim. You can only get access to that document if you've told the court about whether there are non-protocol vehicle costs and what they are. Hopefully you're all following this so far. The same for that applies effectively to all the other stages of the dispute. I'm going to skip very quickly because of the time. So that's how it works for liability. You fill out the form, off you go. Once the court has decided liability, assuming that liability is found to some extent, you then return to the portal and you pick it up at the quantum stage. So in other words, you then need a Medco report for your whiplash. You then start making offers to the defendant. If you don't resolve the matter, you then fill out the second form and off you go back into the next stage of the practice direction and you have a new claim. And the court can then deal with that element, i.e. the quantum element of it. So that is how you can bounce between the two. And as I say, you can also bounce if, for example, an interim payment was requested and not paid, or if there were difficulties and arguments over fees. Again, each one is as a form on the online portal. The claimant fills it out, and then the defendant has a set time to respond in their own form, and that is then what generates a court pack to allow the court to then resolve it. That's the system in general terms. None of that bites against non-portal costs, and so if when you get to quantum, there is also a stonking credit hire claim, for example, that either needs to be dealt with outside of the small claims track because it's more than £10,000, or is there and hasn't been resolved because it doesn't fall in the protocol, then the court will then give directions as appropriate to deal with that part of the claim. So, for example, it could then be that it becomes a fast-track matter to deal with the credit hire issue. I'm going to very quickly just deal with the other issues. Online portal, one big bone of contention, there's no alternative dispute system in there. So a claimant who doesn't agree with the defendant's quantification of the claim, particularly if they're acting in person, it's very difficult to know how they're going to do anything other than simply issue their claim, because no one's going to be advising them really as to what an appropriate figure is. Maybe not so difficult for the tariff bit, but of course that catches also non-tariff damages and of course their protocol costs, which might be, for example, their excess or some other costs they've been put to. I mentioned their paper version. They have to send a paper version, and that's going to give rise to some difficulties for some claimants. And digital disenfranchisement, I would struggle to believe that many claimants are going to be able to deal with this, simply because it is quite complicated as a system, and the online system is quite complicated. I think there is a naive assumption that many people have access to the internet at all, and certainly have the ability to use it in a way that will allow them to navigate this. Which leads me to my final point, which is I think, as a result of all of this, it is unlikely that claimants who want to bring the claims are going to do so on their own. I anticipate either solicitors will have to be involved in some way, possibly as of an adjunct to a larger credit hire claim, and it's part and parcel of the service offered, or I fear, I'm afraid, more accurately, accident management companies will row into the frame, because someone somewhere, I suspect, is going to have to help claimants navigate their way through this. I conclude where I started, although I've run over time very slightly, with the picture says it all. All of that new sea change, I remind you of the words of Chris Galing, is to save each and every one on this phone call £35 on their insurance premium. That's what it's designed to achieve. Whether it achieves it, we will see in due course. That concludes the talk, which I accept is probably a little bit whistle-stop, but I don't know whether there are any questions that have been coming in that Roger has either not dealt with or would require input from me on. Let me have a look. Roger, are there any?
There are some questions.
Yes.
Yeah, there are some questions. I'm just saying this 2, whether you need to come back in writing to them, but
well, people obviously can log off when they want. I will shall I rattle through some of the questions that I see. So Roger, you've dealt with that one. Whiplash associated tinnitus. Good question from Rakesh, I see. I think that's back to the definition of connected and associated. I can see arguments either way. Will that form part of a connected injury and therefore be outside? Will it be associated and in? I don't know. I would have thought, given the general damages awarded for tinnitus, the courts, certainly this court, would strive to find that tinnitus, where it was present, was a separate injury. And so either was compensated in its own right, or if it was connected, it was a connected injury to the neck pain and therefore took the whole matter outside of whiplash. That would be my view on it. Roger, I don't know if you have... Oh, you've answered that one, I see.
Oh, I have answered that one, yeah.
And you agree, excellent. Roger, are there any questions you saw that need me to...
Yeah. Do the tariffs distinguish between neck or back?
No. Well,
and
yes
compared
and
to neck and back.
Exactly, it's neck, back and shoulders. So it's what I think if you suffer all three and or any one of, you fall within the tariff. Which again maybe seem unfair, but that's the way it's done. If FD is alleged, yes, the small claims track limit does still apply. I was going to comment on this. Query, however, whether the courts will want to deal with such cases on the small claims track, because a court is not required to allocate a case to its normal track. Like in the good old days when fraud took things into the multi-track, I can see that many courts might be more comfortable dealing with fraud and fundamental dishonesty on the fast track. So that even though the value and the rules would say the normal track is the small claims, I certainly wouldn't be surprised if some judges would say, no, this needs, as it's been pleaded and it's an FD case or a fraud case, this needs to go into the fast track or indeed possibly the multi-track. Roger, what do you think about that?
Yeah, I agree with that. There's a question from Richard Thorpe. Would you expect minors who are compensated by the tariff to still require court approval? If not approved, then any increase in the tariff when the minor attains majority could leave them claiming the balance.
Good question, I think is probably what I'm going to say to that. What a difficult set of facts. I think you probably will still require court approval. I'd have to double check whether Part 21 has been amended, but I don't think it has, in which case you would still require approval of any settlement for a child. I doubt they would be able to claim the uplift if they delayed until they brought the claim, although, albeit, I can see that's quite an interesting argument. Roger, do you have any thoughts on that?
Well, I would certainly thought that approval would be required. You know, it stands to reason, doesn't it?
Yeah.
So, yeah.
If you delayed until you were now an adult, well, the whiplash injury would still be the same. So the tariff, whether you're a child or an adult. Yeah, I think that's quite interesting. I mean, for what it's worth, I suspect very quickly there'll be a streamlined approval system because effectively the judge isn't doing anything. Because if it's a tariff, there's no judicial discretion to be applied as to whether or not the award is correct. So I suspect if it hasn't been amended already, there will be some form of streamlined system to deal with such cases where the only injury is whiplash. But of course, more often than not, there'll be another injury, I anticipate, you know, banged elbow, shoulder, you know, knee or something, which may well require input from the court anyway. So that would be my view on it, but I suspect there will be a streamlined system in due course.
There's another question. Will a child claim, from Rhys James, will a child claim have to be submitted through the existing portal, in brackets, even though the new upcoming tariffs will apply, close brackets?
Yes, is my view on that. I think the new portal effectively is done by an exclusionary approach. So in other words, if you don't fall in the new portal, you still remain subject to the old portals. So any previous portal that would have applied but for the coming into force of the new portal still applies to you. So yes, I think you would.
Thank you. And then finally, I think from Chloe Edwards, this is more technical, maybe we need to check on the websites, but...
They are. No, I can answer that. They are. Yeah. Well, so they're supposed to be, Chloe, more accurately. But yes, that's where they're supposed to access them. And indeed, there are defendant forms. I haven't bored you with the precise all the full names, because actually the website sort of is quite self-explanatory, but there's similar RTASCD forms for defendants, which again are accessed on the website. There's a quite just on offers, just anyone who's still here and who's not had to go back and finish their lunches. The offers is particularly interesting, the way they've structured it under the pre-action protocol. And there's a sort of a lockstep setup as well, so that when one party is doing their bit, so filling out information or considering making an offer, the other party are locked out from doing anything on the website. So it really is almost like a table tennis approach, that you have to wait for the other side to do something before you can. So you'd only get your form once the claimant has done their form and done their bit of it. That's the intention behind the website.
And I think very finally, former Nicholas Scrivens, if FD alleged and it drops out of presumably the small claims track limit, £5,000 still applies.
Yeah, Nicola, that's the exact point I was just trying to respond to. Yes, it does in theory, but as with, imagine if you had a low value personal injury claim now, which is valued at under £1,000, if in fact you were arguing that the claimant was fundamentally dishonest, many judges, not all, but many judges, I think, would be more comfortable putting that in a cost-bearing track so that the claimant could have legal representation. Because for those not used to the way the small claims track works, it's a bit of a Wild West free-for-all at the moment. There are theoretically rules of evidence, and documents are supposed to be served 14 days before a hearing, but it's all a bit more hit and miss than that. And I think if something as serious as fundamental dishonesty was properly raised, and obviously raised, certainly I think many judges would say, well, yes, value, it should be on the small claims, but I have discretion. Certainly this judge would be receptive to an argument that it should go on a higher track.
I anticipate much litigation as to whether or not it should be shifted to another track where FD is alleged. And indeed, the case law in terms of, for example, Howlett, provides quite clearly that FD doesn't have to be pleaded until the submissions, frankly. So there's a dichotomy here, isn't there? Because the new reforms require FD to be brought forward, whereas the case law says not. And very often, frankly, the reason why Howlett is there is because often, in the cases I deal with, I'm sure Simon too, the evidence of FD isn't necessarily there on the papers. It's something that often comes out during cross-examination when suddenly things slip up. So yes, watch this space, I'm sure.
Roger, I agree entirely, Roger. The only thing I would say is I wonder whether this will encourage defendants to go back to actually sort of the pre-Casey Cartwright and Cleasley Clarfeld stage, where allegations of fraud were being pleaded up front. Actually, in those days, it was so that the defendants could get their own expert evidence because of various comments in some authorities. But I wonder if we'll almost revert back to that, which this is a reason why defendants might want to front load the argument, because Roger's absolutely right. Howlett says it might only arise in cross-examination, but it might be that if you are looking as a defendant, although whether you'd want to is a different issue, but if you're looking to get it out of the small claims track, that you might want to plead it early, and indeed claimants might want to try and flush defendants out early. I see Ella has commented exactly right, that in the practice direction it says dispute allegations of dishonesty not usually suitable, though of course I think that's probably in the context where these personal injury cases aren't usually looked at in the small claims track, because up till now it's a pretty de minimis injury that got you up to £1,000. There's going to be vastly more cases where this is going to bite. But absolutely the right point, Ella, I agree. That sort of reinforces what I think hopefully we were saying.
Certainly I've seen, if we take by analogy, cases where it ordinarily would be in the multi-track because of the financial value of the credit hire claim rather than the small personal injury claim, when I've been arguing for that it should still stay in the fast track because it's just a number, the credit hire issue, and it could all still be dealt with in one day, the claimants will readily argue that, well, if they've expressly argued fundamental dishonesty, that's even more reason why it should go to the multi-track. And I can see lots of satellite litigation and directions hearings about all these issues.
Yes, I saw Roger. I'm just looking at the chat function. Is it Michelle Gill has said that she'd like to have a chat with some common issues? And Roger, I'm sure I speak for both of us that both of us are happy to take emails to chambers, telephone calls, Teams, let's be modern about this. Teams calls. If people have specific questions, I think on either element, either the credit hire or the protocol, and I suspect Roger and I would, whoever you can get hold of, would be happy to deal with those, because they are quite fact-sensitive issues. Each case, I'm afraid, is probably going to have to be looked at quite carefully to see where it fits in and what path it needs to take on the new system as it's intended to apply. Roger, I hope I don't speak out of turn for you.
Okay.
So speaking of which leads me rather neatly, look at that for professional segueing. There are our email addresses. So I will leave those on the screen for a period of time so that people don't have to scrabble around too much. That's probably the easiest way to contact both of us, although our clerk's room is open, I think, so you can call our, certainly from Monday, our clerk's room is open, so you can telephone the clerks if you want to get hold of either of us. Are there, Roger, have we exhausted all of our questions?
I believe so, yes. Excellent.
Well, thank you very much, everyone, for engaging and all of your helpful questions. I'm going to talk slightly slowly now, just in case anyone has a burning question that they want to fire up, because this is your sort of last warning that we're about to draw the hearing to a conclusion.
Oh, there's 2 new messages. Hang on, what's this? Well, PD20 from Ella Davis.
That's that one, yeah. And then you're more than welcome, Richard and Dawn, and indeed to everybody else. As I said, any follow-up questions, please feel free to email either Roger or I. This presentation, which has obviously the details on it in terms of the case references Roger was referring to, the practice directions and the like, will be emailed to you, so you can review that at your leisure, if that's how you enjoy taking your leisure. Certainly from my point of view, that's everything, Roger.
Thank you very much to all for attending, and thanks from people who've also put questions too. Keep safe.
Good day. Stay safe.